Thank you. Good morning and welcome to this licensing subcommittee. This is a virtual subcommittee meeting that is being conducted with members, officers and members of the public at various locations communicating via Zoom. There is also the opportunity for the public and press to listen and view proceedings on our YouTube channel. Please note the meeting is being live streamed and the recording will be made available following the meeting on the YouTube channel. Before the meeting starts, I'd like to confirm that members and officers are in attendance and can hear and be heard. Councillor Stephen Patmore.
Yes, I can hear.
Councillor Tim Johnson.
Yes, thank you. Good morning.
Councillor Stuart Willoughby.
You're on mute, Stuart.
I don't know how that happened. Sorry. Yes, I can hear you.
And Councillor Alistair Willoughby.
Yes, good morning.
Thank you. And officers, I've got Sharon Bartram.
Yes, thanks very much.
Jasmine Jennings.
Yeah, all good.
Samawa.
Present.
Alina.
Yes, thank you very much.
Alan Stone.
Good morning. Yeah, hi, thank you.
Scott Grant.
Good morning, all. Yes, I can hear. Thank you.
And then I have Anthony Evans-Pugh. Not showing you with a mic at the moment. Okay, we'll come back. Have I got Christine Evans-Pugh here? Might have to wait for them to confirm that they're here. We'll just be bearing with it. I'll go through the rest of the people, which is Tony Miselli.
Yes, I'm here.
Thank you, Tony. And Frank Fender.
Yes, good morning. I'm present. Thank you.
Okay, I'll just try and find out what's happening with the Evans-Pughs before we start. So just bear with us for a moment, please. Hello, do I have Anthony?
Yes, hello.
Thank you, Anthony. Sorry, it's all right. Just before we want to make sure everyone is here before we start. Okay, we'll move on. Our first item is the election of a chair. Can I please have nominations for a chair from a councillor, please?
Tim Johnson.
Thank you, Councillor Patmore, for nominating Tim Johnson. And a seconder, please.
I'll second that.
Thank you, Stuart. Councillor Willoughby. Okay, if there are no objections from members, then I confirm that Councillor Tim Johnson is therefore elected as chair for this meeting, and I'll hand over to them.
Thank you, Janelle, and welcome everybody to this application meeting. Do I firstly have any nominations for the reserve member, please?
Happy to self-nominate for myself.
Thank you. Thank you. And could I have a seconder for Councillor Willoughby?
Yep, I'll second.
Thank you. So Councillor Willoughby, Alistair Willoughby, is therefore the reserve member at this subcommittee meeting. Could I please invite the committee clerk to outline the hearing preliminary, which is details on page 3 of the agenda?
Thank you, Chair. The subcommittee will consist of 3 voting members with a 4th non-participating member listening to the hearing. In the event that a voting member loses connection, the hearing will adjourn until connection can be restored. If the adjournment exceeds 10 minutes, or it is apparent sooner that reconnection will not be possible, the 4th member will replace the absent member and become a voting member on the subcommittee. If a quorum of 3 members that have been present throughout the hearing is not possible, the hearing will be adjourned to a stated date. Applicant. In the event that the applicant loses connection, the hearing will adjourn until connection can be restored. If it becomes apparent that the reconnection will not be possible, the hearing will be adjourned to a stated date. Environmental Protection Officer. In the event that the Environmental Protection Officer loses connection, the hearing will be adjourned until connection can be restored. If it becomes apparent that the reconnection will not be possible, the hearing will be adjourned to a stated date. Other persons. In the event that the other persons that has indicated their wish to speak loses connection, the hearing will adjourn until connection can be restored. If it then becomes apparent that reconnection will not be possible, the hearing will be adjourned to a stated date. If an other person has indicated that they will not be participating orally in the hearing loses connection, the chair may decide to continue with the hearing. Decision. The subcommittee will undertake their deliberations in private and return to announce their determination on the live stream. However, they will not wait until all parties are connected. A copy of the decision will be forwarded to all parties electronically as soon as practical. Are there any questions before we start the meeting? Okay, I will now hand back to the chair.
Many thanks. Could I please now invite the legal advisor, Samao Paxikato, to outline the matters for consideration at this meeting?
Thank you, Chair. The subcommittee is concerned obviously with an application under Section 34 to vary of the Licensing Act to vary premises license. The nature of the variations are set out in the application, but can be summarised as follows. It's applied to vary alcohol sales from 11:30 to 1 a.m. on Fridays and Saturdays. That live music should be extended from 11:30 p.m. to 1 a.m. on Fridays and Saturdays, and that there should be late night refreshment indoors only from 11 p.m. to 1 a.m. on Fridays and Saturdays. It's also understood that the applicant is seeking for the closing hours to change from midnight until 1:30 a.m. on Fridays and Saturdays, and where Christmas Eve and New Year's Eve falls on a Friday, does not fall on a Friday and Saturday, they wish to also have extended hours on those dates. The committee's powers under Section 35 of the Act is to either modify the conditions of the licence, reject the whole or part of it of the application, having taken into account all the relevant representations received today about the likely effect of the grant on the promotion of the licensing objectives. Those are the prevention of crime and disorder, 2, public safety, 3, the prevention of public nuisance, and 4, protection of children from harm. In particular, in relation to this application, the prevention of crime and disorder and the prevention of public nuisance are likely particularly important, but the committee is asked to consider all the objectives insofar as they become relevant. This committee will have noticed that representations have been received by the Environmental Protection Department and that there are also 2 representations received by third parties. Legally, the committee must have regard to any representation that is not, in the opinion of the committee, frivolous or vexatious. If any representation is frivolous or vexatious, you're required to provide your reasons for that. The police have not made any representations, but some conditions have been agreed in the event that the application is successful. Finally, obviously, if the committee does approve the application, you must give your reasons for doing so. I wish to just raise one additional part for the benefit not just of the committee, but for those who are appearing at this committee hearing today and before any representations are made. In particular, the committee will have noted from the representations received from Environmental Health that the premises are a Grade 2 listed building. Therefore, the local authorities' specific local licensing policies may be relevant, and in particular, those participating are referred to Section E3.4, which concerns the use of equipment, including installation of acoustic enclosures or barriers, and the expectation that where measures require planning consent, that those would have been discussed prior to any changes having been made, and that the Licence Committee is entitled to receive reports and considerations on planning considerations that may affect the premises. The planning process and the licensing process are of course distinct, but it of course is beneficial that there shouldn't be a clear conflict between the separate regimes, but at all times this committee must make its decisions having regards to the particular licensing objectives. So insofar as a planning consideration may be relevant, it it still must be justified within the framework of the licensing objectives. That is all the advice that I have at this moment in time, but there may be further matters depending on what arises throughout this hearing.
Thank you very much for that. Could I please now invite Sharon Bartram, the licensing officer, to present any additions or amendments to the report?
Thank you, Chair. There are no amendments to the published report. However, I have some comments in relation to today's hearing that may assist. The application is for the variation of an existing premises licence, where you will hear evidence of issues already being experienced by residents. The subcommittee can only consider the requested variation. It cannot make any amendments to the existing licence. You'll see from the report that officers are considering their options in regard to the operation of the current licence. Evidence of the management of the premises and allegations of issues being experienced are relevant to the hearing, as the subcommittee will need to consider how much confidence they have in the premises management to operate within the requested additional hours. In particular, a noise management plan has been proposed, which should the subcommittee be minded to grant the application, will require the licence holder to comply with additional conditions over and above those already imposed on the existing licence. The two licensing objectives raised in representations are the prevention of crime and disorder. This relates to matters of crime and disorder on or in the immediate vicinity of the premises which fall within the control of the licence holder. Prevention of public nuisance. This relates to nuisance coming from or associated with the premises and can cover more matters of noise, light, litter or odour. Examples are music or people noise coming from the premises, or noise nuisance directly associated with the premises, such as vehicle or people noise outside the premises. It is the responsibility of the applicant to promote the licensing objectives and fully understand their responsibilities when managing the premises. The applicant must demonstrate in the application that they've assessed the likely impact of the application and taken appropriate steps to mitigate any issues. Objectors must confine their oral submissions to matters included within their submitted representations, although these matters can be expanded upon. Comparisons with operating hours of other premises are not relevant to today's hearing, as each application should be determined on its own merits, considering the impact on the licensing objectives and the competence of the premises management. As part of the objectors' submissions, the Council has received sound and video recordings. These recordings have captured pictures of persons that have not consented to their images being shown in the public forum. Therefore, it is suggested that the hearing moves into a private session to view these recordings prior to the objectors' oral submissions. Oral submissions can be made in the public hearing. When considering the impact of noise outside the premises, the subcommittee should be aware that Bucklesbury is a thoroughfare to and from the marketplace and also contains other licensed premises. If relying on evidence of nuisance outside the premises, the subcommittee should be confident that this is being caused by patrons of Let's Party and that it is within the applicant's control to resolve. The subcommittee will also have read allegations of harassment of the objectors by the applicant and patrons of the premises. The Licensing Act is not the only legislation available to deal with such allegations, and these matters have been brought to the attention of the police. The subcommittee will have read that the police are satisfied that the application can be granted, subject to the conditions that they have agreed with the applicant. The subcommittee should be aware that the police have raised the issue of harassment, that the police could have raised the issue of harassment had they deemed it appropriate, but they've chosen not to do so. The statutory guidance does suggest that subcommittees look to the police as the primary authority on matters of crime and disorder. There is also a representation from an officer of the Environmental Protection and Housing team in regard to noise nuisance. The subcommittee should have regard to the fact that the officer has tried to work with the applicant by not objecting to a series of temporary event notices in order to assess the likely impact of later hours. When considering the weight to put on the officer's representation, it should have regard to the officer being a trained professional in their field of expertise. Mediation between parties has been attempted, however, it was unsuccessful. Paragraph B6 of the Council's licensing policy states its vision as to ensure that North Hertfordshire continues to offer a diverse range of well-managed licensed venues and community and cultural activities within a safe and enjoyable environment in both the daytime and nighttime economy. Paragraph B9 expands on this and states, in making a balanced decision, the council accepts that those living in town centre environments are likely to experience a degree of disturbance associated with a vibrant nighttime economy, but this must be managed in such a way to limit its impact beyond that which is reasonable. The council will at all times consider the wider benefits to and impacts on the community as a whole, and will take a proportionate view on the weight to apply to representations. This is the crux of the determination process today. If the subcommittee believes there is a nuisance to residents, is that nuisance reasonable within the hours proposed, having regard to the council's vision for licensing? Would the licensing objective of the prevention of public nuisance be adequately promoted if this application was granted? In making its determination, the subcommittee should be aware that the Act is permissive, therefore, should begin their deliberations by asking themselves, having regard to the promotion of the licensing objectives and the evidence before them, can the application be granted as applied for? If so, it must be granted. If not, can appropriate and proportionate conditions be imposed to mitigate any issues to ensure the promotion of the licensing objectives? If so, the subcommittee must impose the conditions and grant the application. If not, the application must be refused. I'm happy to answer questions now or during the hearing at your discretion, Chair. Thank you.
Thank you very much for that update. I'm going to give everybody the opportunity to have any points of clarification, but I'll go in order of firstly, I believe it's Mr. Evans-Pugh of the other persons. Do you have any points of clarification for the licensing officer?
Sorry, I was on mute. No questions. Thank you.
Okay, thank you. Does the Environmental Protection Officer have any points of clarification for the licensing officer?
No questions. Thank you, Chair.
Thank you. Mr. Maselli, good morning, and Mr. Fender, good morning. Do you either of you, sorry, have any points of clarification for the licensing officer?
I have one question, please, if I may, Chair.
Yes, go ahead.
Sharon, could you confirm that the additional information, i.e. the membership rules and the noise report, which was submitted to you, have also been circulated to members, please?
Yes, I have.
Thank you very much. Thank you, Chair.
Thank you. Do any members have any points or clarification for the licensing officer? I'll take silence unless anybody's on mute and talking as no. Okay. Can I please now invite the applicant's representative, Mr. Fender, to present their submission supporting the application?
Yes, thank you, Chair. Good morning. Good morning, councillors. Good morning, everybody.
Good morning.
Let's Party, 26 Bucklersbury, Hitchin. It's a small town centre bar which specialises in providing karaoke entertainment for its customers. When I say a small town centre bar, it has a capacity of up to 40 persons. There is, as we've heard, an existing premises licence for these premises. That premises licence is contained at pages 29 to 33 of your report. The premises licence lists the current permitted activities and the current permitted times for those activities. That is summarised at page 27 of your report. Also summarised on the same page is an explanation of today's application. What are we applying for? We are applying to extend the hours for licensable activity on a Friday and a Saturday until 0100 hours the following day. We are applying to add regulated entertainment on a Friday and a Saturday until 0100 hours the following day. We are applying to add late night refreshment to the list of permitted activities to be allowed from 2300 until 0100 on a Friday and a Saturday, and we are also applying to allow the licensable activities until 0100 hours on Christmas Eve and New Year's Eve. With the activities concluding at 0100 hours, it is also asked that the closing of the premises on a Friday and a Saturday would be 0130 hours. With the application was sent a noise management plan, and there is an additional condition proposed within the application to the effect that the premises will operate in accordance with the noise management plan. The noise management plan addresses issues which will reduce or minimise the potential for nuisance to be caused. Some of the detail in the noise management plan includes having a staff member at the entrance/exit of the premises to control customers' behaviour on entering and on leaving the premises. That staff member would undoubtedly be the door supervisor, which was a condition proposed by the police, which has been readily accepted by the applicant, Mr. Michelli. Another detail in the noise management plan includes a measure to reduce the tempo of the music towards the end of the night. We all agree that the mood of the music can affect the mood of the customers when leaving. So by reducing the tempo, calming the music down, it will undoubtedly calm the customers down as well. Another measure involves increasing the lighting levels at the premises towards the end of the evening, which acts as a message to customers that the premises will be closing, things are quietening down, and with their mood being appropriately adjusted as well. On the existing premises licence, there are conditions restricting the times that deliveries, waste collections and glass refuge replaced in bins can be undertaken. It is proposed that those two conditions are removed from the existing licence, and there are two measures within the noise management plan which effectively extend the times that those activities are not allowed to take place, so a much tighter restriction on those activities. The noise management plan proposes several measures which you could translate into individual conditions on the licence if you are minded to grant today's variation application. Or you could impose a single condition to the effect that the premises shall operate in accordance with the noise management plan submitted. The plan may need to be given a reference number in order to identify it, should this be the case. You will also note within the noise management plan that there is an intended use of acoustic pads. Acoustic pads hang at the front of the premises and assist to prevent noise breakout. These pads were tested this week on Tuesday morning by a noise sound acoustic expert. The additional information provided to you is his brief report from Tuesday morning's tests. I'm no expert in noise levels. I'm sure Mr. Stone may well have something to say about this, but my understanding from that report is that the music was played in the premises on Tuesday morning at a level of 91 decibels. Out in the street without the pads, 59 decibel level was recorded. With the pads in place, a 52 decibel level was read. So there was an obvious reduction in noise breakout by the use of those pads. 59, 52 decibels doesn't mean a great deal to me, but it is my understanding that decibel levels of between 31 and 60 decibels amounts to a normal conversation. That's my understanding. I stand to be corrected. Mr. Stone, I'm sure, may well have something to say about that. As we know, we have representations to the application, the neighbours either side of the premises, and the council's environmental health officer, Mr. Stone. The representations from the neighbours make several references to the character of Mr. Michelli, the applicant. Can I remind the subcommittee that today's hearing is not to decide on the character of Mr. Michelli. It is to determine whether the granting of today's variation application would undermine the licensing objectives. In your report on page 25, paragraphs 8.12 and 8.13, it tells you that the focus of your determination is on the variation only, nothing else. I quote paragraph 8.12. The subcommittee can only consider the effect or likely effect of the variation applied for. It cannot consider amending the existing licence, as that would be a matter for a review. 8.13 states that if the application is rejected, the existing licence will continue in its current format. So we're focusing on the variation application, not on Mr. Michelli's character. I don't propose to go into detail and contest anything contained within the representations from the neighbours. It is everybody's democratic right to make a representation to any application, and their representations are respected, if not even though they might not be agreed by the applicant. Their right to make a representation is respected, and they are what they are. But what I will say is that as a result of looking at those representations, Mr. Michelli has given further consideration as to how he can reduce and minimise the potential for noise breakout from the premises. He's also considered whether anything else could be done to try and control the behaviour of his customers. He therefore proposes to operate, should this application be granted, he proposes to operate a membership scheme, a scheme whereby all customers who are still in the premises after 10:30 on a Friday or a Saturday evening must be a member. Those members will have to provide personal details. Therefore, the identification of all persons present will be known to Mr. Michelli. Members will be expected to sign an agreement to comply with a set of rules. That's the set of rules which was forwarded to you as additional information. Non-compliance with those rules will result in the membership being terminated, which would mean they could not go into the premises after 10:30 on a Friday or Saturday night. It could even lead to their permanent exclusion from the premises. In summary, Chair, Mr. Michelli is a businessman. He has provided karaoke entertainment for his customers for the past 12 months. There is a clear market demand for such entertainment, and these extended hours applied for are largely as a result of his customers wanting to enjoy this form of entertainment for longer on a Friday and a Saturday. Mr. Michelli has faced many challenges in providing this form of entertainment. He has neighbouring properties which share party walls with his premises. His premises is also located within a narrow street within the town centre. The narrowness of the street can make the premises sound louder than it actually is. Over the months, he has tried to be a good neighbour. He has put things in place to reduce noise nuisance. He has spent money on soundproofing. He has relocated the entertainment area from the rear of the ground floor to the front of the ground floor, away from the party wall. And in spite of his best efforts, he remains frustrated in that by carrying out these works, the noise complaints persist. This has had a detrimental effect on his relationship with his neighbours, which is a shame. He has been finding it difficult to balance the needs of his business and the needs of his neighbours, but he continues to try to achieve this, which is why he proposes these additional conditions within the application to extend the times for the licensable activity on a Friday and Saturday. Frustrated? Yes, he is, but he still wants to be able to operate without upsetting those who live next door. His character is brought into question within the representations of the neighbours, but as I've said before, this hearing is not to make decisions about his character. It is about the promotion of the licensing objectives. You've heard that the applicant, Mr. Michelli, has agreed 3 additional conditions with the police in respect of the provision of door supervisors. The police have therefore not made a representation to this application, and as your officer said in her introduction, the police are happy that this application can be granted. I would therefore ask you to grant the application as applied for, with the additional conditions in respect of noise and the additional conditions in respect of membership scheme, to to allow these activities to take place as applied for. I'll give way to questions, Chair. That is the application before you this morning.
Thank you, Mr. Fender, for that detailed application. And just to reaffirm what you said, we are very aware of the criteria of this subcommittee and what we're looking at, which is the variation. But thank you for pointing that out. I just before I go around everybody again, I just have one question myself, and I appreciate the police have suggested this, but is Mr. Michelli confident that a minimum of one door supervisor, if that's what happens, is sufficient as opposed to two or more?
Yeah, Mr. Michelli has been using the services of one door supervisor, and that seems to have worked.
Okay, thank you. So I'll go around everybody, give everybody an opportunity, as I said before. Firstly, does the Environmental Protection Officer have any points of clarification for the applicant?
Yes, Chair, thank you. Mr. Fender, at the noise management plan is at page 51 of the bundle. In paragraph 6 of that noise management plan, it says, where amplified music is planned to form part of regulated entertainment, it will be demonstrated either subjectively or otherwise that noise levels will be reasonable at the boundary of the event or be barely audible at the nearest residential receptors. There's no detail on how that's going to be achieved. Can you clarify that, please?
Yeah, quite often those sort of checks are carried out by literally going to stand in the street to assess the noise levels which are emanating from the premises. It's widely believed that now that the entertainment area has been moved from the rear of the premises to the front, the noise breakout appears to be coming from an upstairs window, which has been either opened by customers without the knowledge of the applicant or by the applicant himself. There is a measure within the noise management plan to keep windows and doors closed, with the exception of access and egress, as you would expect. We know that the window was opened by customers, which created an issue a few weeks ago. Mr. Michelli is quite happy to secure that window to make sure no noise breaks out from there. But he's confident that with that window being closed and the hanging of the acoustic pads, which now go right across the frontage of the premises, I believe that you've seen 2 of the pads previously, but there's now 4 pads which go across the entire frontage. You've seen the result of the noise test carried out on Tuesday morning. It seems to reduce the noise levels to that of a simple conversation.
Okay, thank
Environmental. Anything else, Mr. Stone?
I will address other matters in my submission. Thank you.
Yes, thank you. Do any of the other persons, Mr. Evans-Pugh, have any points of clarification for the applicant?
No, thank you. No points.
Thank you. Do any members have any points or clarification for the applicant? Again, unless people are muted, I'll take silence as no. Oh, yes,
please.
Sorry, go ahead.
Yeah, just a couple of points. From what point in the day would the acoustic pads be applied? And secondly, if they are applied, do they in any way affect the exit from the premises in the case of an emergency?
Okay, thank you, Mr. Fender.
Yes, thank you. Tony, if I could ask you to answer the question about what time you would put the acoustic pads up at the front of the building. I did have a photograph which I was unable to send to the committee showing the pads in place. There are 4 pads that hang down. The width of
I've received that, actually. Sorry to interrupt you. We've got that. Yes,
right. You will see there's 4 pads. They could be just literally pushed aside to allow access and egress into the premises. They're not sort of, it's my understanding, and Tony, please correct me if I'm wrong, but it's not my understanding that they are zipped fast together to sort of lock people in. They allow easy access and egress. Tony, could you advise on the times, please?
Right. 3 of the pads I'm actually leaving up permanently. The 4th I'll apply after the 10:30. And they just literally hook on. Easy enough. Is that good enough?
Sorry, can I just come back on that? Would they
ahead.
possibly create an issue if they were to be pulled off with people trying to escape fairly quickly? Would that not form some kind of potential barrier that people could trip over when they're trying to come out?
It takes literally 1 second to pull off and put to one side.
Okay, yeah. And at what point will the supervisor be operating the at the front door?
From 8 o'clock.
8 o'clock onwards?
Yeah.
Okay. Thank you.
Thank you.
Thank you. Just, I think I'll ask at this point as well, perhaps the legal advisor, could I just ask about the, it was said, wasn't it, it's a grade 2 listed building. Do these pads have any effect on the planning issues regarding the building?
As the committee would have heard at the beginning in terms of the advice, this is a grade 2 listed building, and therefore, because it's a grade 2 listed building, the expectation would be that the applicant should have had a discussion or raised the issue about whether the nature of these pads, given how they are currently affixed or appear to be affixed to the building, as well as the character, whether or not they would effectively conflict, obviously, with the current planning controls in relation to that into that premises. Now, it may be that there's further information that's going to come out, but at this moment in time, I think Mr. Fender hasn't addressed any issues in relation to planning, and it's not clear whether there's been any discussions with planning in relation to these pads. The photographs provided to this committee suggest that these pads are already in place at this moment in time, which would suggest that, given that they are in place, there should have been approval or listed building consent from planning.
Okay, Mr. Fender or Mr. Michelli? Yes, please do.
Yeah, but if I may, please, Chair. These pads are not a permanent feature. Once they hang up, at the end of the day, they'll be taken down and placed inside the premises. Tony, I believe that's right. Could you just confirm, Tony?
They're no different to curtains.
Yeah, but they do get taken down at the end of the day and put inside.
Yeah, you can take them on and off on hooks.
Yeah. Okay. Thank you. With regards to planning, not taking anything away from your legal advisor's advice, but as he has correctly identified, the planning laws, the licensing laws are independent of each other. What Mr. Chelly is fully aware of is that just because you get a permission under a license, that does not negate any obligations under planning or any other form of legislation whatsoever, be it a grade 2 listed building or what have you. Mr. Michelli must be compliant with both regimes. It's my understanding that I don't think any consultation has taken place with building control, planning, etc. at this stage, but should this application be granted and the intention is to put those pads in place, then Mr. Michelli would obviously seek that permission from the relevant department of the council in order to be able to do that, because he must be compliant with both regimes, planning and licensing.
Yes, yeah, points taken. Thank you. Could it just finally on this aspect, could I just ask you, Mr. Fender or Mr. Michelli, I think it was said a few minutes ago that these pads are going to be up all the time. Can you just clarify that? Are we talking about all the time during opening hours, right from the start in the morning through to the evening, or what is the situation?
Well, it would be my advice to Mr. Michelli that he needs to put those pads up whenever karaoke entertainment is taking place at the premises.
Okay, is there an intention, Mr. Michelli, to have them up permanently even when the premises are closed, or are they going to be taken down each time?
Taking them down are easy. I'll ask the appropriate authorities if I have to. If I have to take them down, that's not a problem. If I can stay up, I don't mind doing that either. But they would definitely be in place when karaoke is taking place.
Fine, thank you. And I appreciate whose authority it is about the planning, but I was just intrigued as to whether they were staying up permanently or not. But yeah, thank you for clarifying that.
No problem.
Unless anybody else has got any
I
points of clarification?
Can
Any
I,
other points?
Yes. Hello?
Yes, go ahead. Sorry. Go ahead, Councillor
Sorry.
Willoughby.
I've got a couple of questions, if I may. Can I just ask, so obviously you said it's obviously quite a small venue. Can I ask, other than the door supervisor, what other staff do you have in the building during opening times?
Yeah, every Friday and Saturday night there's a there will be a door supervisor plus 4 other members of staff.
And of the 4 other members of staff, so is Tony Michelli counted in the 4 other members of staff?
Yes, he is. Yes.
And is Tony Michelli acting as is Tony Michelli the owner, and then do you have a duty manager as well in the building?
Tony is obviously the premises license holder. He's the designated premises supervisor, and then there's 3 other members of staff in addition to Tony.
And are those are those 3 members of staff just junior members of staff, or is one of them the duty manager?
Tony, could you answer that, please?
Well, I suppose you can count me as duty manager, but I have just taken on, beginning of September, another full-time member. So she'll be acting just below me, I suppose.
Okay. Could I just ask then? I've got a couple of questions on this. So at the moment, on your current conditions, the premises license holder and/or designated premises supervisor will ensure that a minimum of 2 persons, namely the owner/DPS and duty manager, are fully trained to access and operate the closed circuit television CCTV system and download copies of any footage upon request by police licensing, etc. One of these persons will be at the premises at all times when the premises are open to public. I'm slightly concerned that at the moment you're not actually in compliance with your current licensing conditions then.
Why? Sorry, councillor. If Tony is able to operate the CCTV and another member of staff can operate the CCTV, I don't understand where the alleged breach would be.
So, namely, the owner, DPS, and duty manager. So you need 2 people on your current license.
Well,
but it's fine.
Sorry, councillor. Sorry for interjecting, but that sort of condition, what the police effectively want from that kind of condition is for there always to be at least one person there that is familiar with the operation of the CCTV, so that any footage could be downloaded on the spot, so to speak, without having, which used to happen in the past. The police would obviously have to wait for an engineer to be called the next day, etc. But by that sort of condition allows footage to be provided straight away.
I mean, that might be the intention of the police, and certainly that is, that might very well be the intention. It's not what's written current, but regardless, we'll move on to my other question, if I may. So, as you say, it's quite a small venue. So, the ground floor, you said that you'd moved the karaoke activity to the front of the building. That's correct, yes. And then upstairs, where is the karaoke located?
Yeah, the karaoke, Tony, and correct me if I'm wrong, but it's on the first floor at the front of the premises. The window looks out on Bucklersbury, onto the road.
Okay. Could I just ask? This is going to sound a little odd, but could I just ask where is? I've been in there before. Is it still the toilet is just up the one upstairs? You got 2, right?
There are 2 toilets, one upstairs and one downstairs.
Brilliant. Thank you. That's all my questions for the moment. Thank you.
Thank you. Just leading on from that, thank you, Councillor Willoughby. I'm just looking at the pictures, Mr. Fender and Mr. Michelli, and again, please do correct me if I'm wrong, but I think you've just said the karaoke is upstairs on the first floor, but these curtains, so to speak, only cover the frontage on the ground floor. Is that right?
Right. Upstairs, we've got one karaoke room, a little karaoke room, that when the windows and the curtains are drawn, we've got heavy duty curtains. You don't hear outside at all. When the window was opened, without my knowledge, yes, the noise does escape.
But just to clarify, the acoustic pads that we've talked about
That's downstairs.
earlier on, that they're on the ground floor. That's
Yes.
right, yeah.
Yeah, we don't need them upstairs. You really don't hear nothing.
Okay, it was just a
Obviously,
clarification.
if someone says you do, well, I'll just get a big pad and put them upstairs as well. But we've got really heavy duty curtains and the window does the job.
Okay, thank you for that clarification.
Thank you.
Can I also add something, Chair? Sorry, I do apologise.
Sorry,
but
yes,
there's-
please
I
go ahead.
believe there's an existing licence condition that the upstairs room is only allowed to be used up to a certain time. And I believe
Right.
that's 10 o'clock, Tony, or 10:30? Yes.
10 o'clock at the
Okay.
moment, yes.
Okay, thank you. Do any other members have any points or clarification for the applicant?
Chair, could the
Okay.
legal advisor speak, please?
Yes, absolutely. Please go ahead. Sorry, carry on.
I'm grateful. Thank you, Chair. Just one point of slight clarification. While I agree with what the representations made by Mr. Fender in relation to the obviously licensing regime and planning being distinct, and therefore even if the application is granted by the licensing committee, that doesn't mean that separately the applicant doesn't have to obviously comply with any planning considerations, but it's important just to raise the specific point that in relation to this committee is obviously considering the equipment put forward by the applicant as provided and the specifics of that. It's important for the applicant to obviously be aware because planning is also distinct. It may be that the equipment which is put forward would not necessarily be accepted by planning because obviously the planning remit gives a wider consideration to a number of matters, and because we are talking about listed building, it's not simply the nature of the acoustic planning. The appearance and various other matters may also be relevant to whether or not they breach planning control.
Okay, thank you. If I miss anybody's hands up, forgive me. Just feel free to shout up if you want to make a point. Any other members would like to make any clarification points? Okay, thank you all for those very detailed answers and from the applicant. Could I now please invite Mr. Alan Stone, the Environmental Protection Officer, to present his submission opposing the application?
Yes, thank you, Chair. My full representation is on page 57 of the bundle. Good morning, everybody. I'm just going to give a brief summary of that now, orally. So in late 2023, a hearing, an application was submitted, a variation application was submitted for the premises, which resulted in a hearing. The variation application also resulted in occupants of nearby residential premises contacting the council to object to the variation, but also to complain about the existing noise from the premises, which they've been trying themselves to mitigate in liaison with Tony Michelli. This resulted in an investigation by the Environmental Protection team into the noise, and then subsequent representation was made at that hearing, which resulted in the licensing committee not granting that variation. The premises continued to trade under its existing license into the new year, and as a result of further investigations, we were satisfied that the existence of a statutory nuisance at the complainant's properties and served an Environmental Protection Act 1990 abatement notice on the premises on the 2nd of February 2024. I'd like to point out this is not something that's undertaken lightly. We have no mind to punitively affect anybody's business. We were satisfied there was significant noise intrusion from the premises based on noise from music and also patrons outside. The noise from the music was going through the party wall to the rear and also coming out to the front facade through the single glazed window and door at that time. Mr. Michelli as has been pointed out, has made some improvements to the premises, which did improve the situation, and the complaints appeared to go away. However, following the application received on the 9th of August, it appeared that this only occurred because one representative was fearful of reprisals, and the second had moved away to some degree to avoid the noise. So following on from the application, I undertook some further investigations to inform my representation today, or for this hearing. And on the 30th of August, between the hours of 2100 and 2300, I sat in the home of the complainant and witnessed noise from the premises, which was clearly audible in the front habitable room. So clearly the mitigation measures that have been put in place weren't satisfactory, and noise was still occurring. In addition to this, a table was positioned across the street for people to smoke at, I believe, which obviously exacerbated the situation because people were using that as a congregation point, which was causing further problems. And also some lights have been placed on the outside of the building, which sort of took the party outside, if you like, created an extension to the venue almost, where people were seemingly more likely to take their celebratory attitude outside. Not saying that. Additionally, a series of recordings were made and submitted to the council by a nearby resident, and that also clearly showed that noise from both people singing, noise from music, and patrons outside were clearly audible in the home of the resident. The Institute of Acoustics have produced a good practice guide on the control of noise from pubs and clubs in March 2003. This has been submitted as part of my representation. And I'll just read out section 2.4, which is on page 59 of your bundle. It gives advice on how premises should operate to minimize any noise disturbance from premises such as this. So section 2.4 says, music, singing and speech, both amplified and non-amplified, are common sources of noise disturbance arising from the premises listed in 2.1 above. As far as these sources are concerned, the purpose of developing the objective noise criteria mentioned in 2.3 should be attempt to ensure that for premises where entertainment takes place on a regular basis, music and associated sources should not be audible inside noise-sensitive properties at any time. In the absence of any objective criteria, mentioning what is regular should be determined on a local basis to reflect local expectations and should it be incorporated by local authorities into their planning and enforcement policies. For premises where entertainment takes place less frequently, music and associated sources should not be audible inside noise-sensitive property between 2300 and 0700 hours. So clearly in this case, what I witnessed following the submission of the variation application, this criteria is not being met. Indeed, on the visit that I made on the 30th of August, the window, as has been mentioned before by Mr. Fender, the window to the premises upstairs room was open, allowing noise to escape. Now, I'm in no position to say that the noise I was experiencing in that property on that occasion on the night of the 30th of August was coming out of that window. I don't know if that's the case. Neither does Mr. Marcelli, and neither does Mr. Fender. No assessment's been taken on that. All I can say is that I heard noise in the property of that complainant on that occasion, which was clearly audible and intrusive, and I could both hear people singing and music. Now, the noise I experienced in that flat was, it's important to say that it was low frequency noise. I wasn't getting a lot of the higher sort of music notes, but what you ended up with was the bass line, if you like, the drum beat. But also people chanting, not just singing. So I think Mr. Marcelli uses a number of microphones, in fact, 4 to 6, sometimes even 10. And that involves, that sort of encourages people to sing as a group, almost like a football chant. And this is something that cannot be readily mitigated by turning the volume down, let's say. It creates its own noise source, and then people tend to go outside and perhaps continue that on. I'd just like to finish up by looking at the additional submissions that were submitted this week. The noise assessment by Roscoe. The first thing I noticed was the noise assessment occurred prior to the existing licensing hours when they played loud music. I mean, that's a moot point, but they did. I'll just go into a little bit of detail. If you want clarification, you can ask afterwards, I guess. But they did seemingly they did a spatial average noise test inside the premises, which is not specified. I don't know how they took that spatial average, but it's about 92 decibels, 91.7 decibels. Then they measured outside the premises at 2 meters from the facade, and then made a calculation based on that on what the mitigation of the fabric of the building was at ground level. They suggested it was around, with the curtain that's been talked about, around about 40 decibels. I would argue that 91 decibels is low for a live music venue. Typically, live music venues operate 93 to 98, even above 100. Now, I don't know how that spatial average was taken, but I'm suggesting that's quite low. And if you take 40 decibels off, let's say 100 decibels inside, which is quite typical for music venues, you're left with 60 decibels outside. 60 decibels outside compared to the background level, which we don't have for the evening, we only have for the morning, is 45. That's 15 decibels above the background level. That's a significant amount of noise above the background level, and in my opinion, will give rise to complaints. Admittedly, that's 2 meters from the facade of the premises, not inside the complainant's house. But equally, that's indicative that there's going to be significant music from noise, 15 decibels above the background of music noise outside. How that translates into the complainant's property, I haven't seen these new blankets in operation. I have no idea. We haven't done any tests on it. What this seems to have been, these blankets, these pads have been put up and seeming like some kind of knee-jerk reaction to what is perceived to be a problem, but yet we don't know what the problems are because we haven't properly addressed the building. Additionally, these decibel levels that are in this report are based on LAQ levels, as specified in the report. That's a broadband measurement, as it's stipulated at the bottom, but doesn't take into account the low frequency nature of music noise, which is more readily transmitted through building structures, and so it becomes more disturbing in neighbouring properties. To do a full and proper test, we'd need to do a test from the residents' properties, which has been, otherwise you're never going to know what the transmission is into those buildings. In relation to Mr. Fender's point about 30 to 60 decibels being a normal conversation, that's a large range, 30 to 60. But if you can imagine that if you were trying to, what we try and achieve in bedrooms, say, for example, is 30 decibels for resting and sleeping in an evening. Clearly, if someone was having a conversation in your bedroom at 60 decibels when you're trying to sleep, that's going to disturb you. The assertion that Mr. Michelli made that the upstairs window is the only problem, I'm not certain that's the case, and I don't think anyone can be at this stage. I'd like to suggest that we're in a position where during the application period, I've witnessed noise levels above which I'm happy with, clearly intrusive, and any extension to the hours of this premises will only exacerbate the situation. But granting an extension to the hours could result in significant additional noise disturbance at a time when the average person might be trying to or expecting to sleep in their home, or certainly relaxing. I'm making this representation to promote the licensing objective to the prevention of public nuisance. I consider this premises, given the location of the building fabric, is not suitable for such activity at these times. And until such time as a proper full report has been done, I recommend an objection to this application. I invite any questions. Thank you.
Thank you very much, Mr. Stone. Again, I'll go around everybody in order, but I just have a couple of questions myself. Mr. Stone, you mentioned on the 30th of August you were there. Did you say at 2100 hours you were in the flat?
I was there from around 2130 to 2300 hours, yeah.
Okay, thank you. And I think you used the words music and chanting, etc., clearly audible and intrusive. Did you not have a decibel level recording from the flat?
No, I didn't. We don't tend to assess static nuisance and decibel levels. We take a subjective view on any noise we experience. There's no set level above which is a problem and below which is not. So we don't tend to measure noise in premises like that. Notwithstanding, it can be quite tricky because of other internal noises. You might not be able to get an accurate reflection of the noise, but we take a view on how we perceive the noise in the premises based on subjective experience.
Okay, thank you. And if I may, before I come to you, Mr. Fender and Mr. Michelli, I'm taking it, but I don't want to presume too much. But there isn't there's not a smoking area with the premises. They have to go into the street. Is that right?
That's yeah. There's one entrance in and out at the front. There's no smoking area per se. It's directly on. Well, there's a slight area, but it's pretty much directly onto the street. And I don't know how Mr. Michelli manages that currently. I think he's tried various options. So there's no option. Yeah, you have to come out the front of the room.
Okay, thanks. Thanks for that. But Mr. Michelli, just on that point, or Mr. Fender, did you want to just make any comment about that specific point about the smoking area?
Tony, could you answer that, please?
Right, we're moving the smokers up the street.
When you say up the street, how do you mean? Where to?
Well, away from the neighbours that are complaining, and we successfully done that. After 10 o'clock.
Yes. So just so how's that achieved then? You literally go out to them, or what do you do?
Yeah, I've just moved on. I've got the doorman to move them on. So after 10 o'clock to just literally smoke away from the neighbours.
Okay. And do I take it there's no specific area? They're just asked to move away from the premises. Is that right or not?
Correct. No idling in front of the premises.
Okay, thank you for that clarification. So
Sorry,
the applicant.
Sorry,
go
could I
ahead.
just ask? Am I allowed to ask just a clarification on that moving the smokers up the street, if I may? I know
Yes,
that
you
obviously
can.
we're supposed to be asking Alan questions, but if I may.
Seeing as I raised it, absolutely, just the specific point, and then you can come in at the end for any other points.
Yeah, absolutely. So where you're moving them up the street, obviously, are there, when they're going up the street, are they just standing there smoking, or are they taking their drinks up there?
Definitely no drinks.
It's unclear.
100% no drinks.
Okay,
There's no drinks allowed outside the premises.
Yeah. And just to clarify, so where can we have the exact location of up the street? What does that look like? Where is that on Bucklesbury?
Sorry, say that again.
Sorry?
Say that again.
Where exactly are they being moved up the street? Is there a
Well, as long as
specific
they're not,
point that
as
they're
long as
being?
they're not in front of the premises and near the neighbours, basically just away.
And then they're coming back into the building afterwards.
Yes. Having said that, we're looking at potentially after a certain time, no re-entry. That's where the membership rules come into it.
Okay. I'm just okay. It's just that obviously if they're walking up and down the street to smoke, are they not making noise? They might not be affecting those neighbours, but then you've got other neighbours presumably who live up that street.
Other neighbours seem okay with other noise on the street.
Well, yes. Okay.
Okay, Councillor Willoughby, is that answered that part? And obviously, would you like to come back at the end? I can invite you. Are you happy that's answered that so far?
It's certainly provided some answer. I think. Thank you.
Yes.
I mean,
Thank you.
Alistair, I'm assuming you're aware of the street. Okay.
Yes,
okay, Mr. Michelli.
Yeah.
If we just stop there then, and I'll now give you and/or Mr. Fender the opportunity to clarify any points that the Environmental Protection Officer has made. Over to you.
Yeah, I'd like to clarify a couple of things. Alan, you mentioned that on your visit at the end of August, you saw the table outside and a light outside. You addressed that when we met post that occurrence. Are you happy that they were just one-offs and following advice, it hasn't happened again?
I don't know if it was one-off. I think it may have happened before, but since we talked about it, I've heard nothing since. I know we verbally talked about that at the meeting that we had, and you suggested that wouldn't happen again. I've seen no evidence of that in any submissions that you've made since, or today you've not mentioned it. So I thought I'd raise that as a potential issue because I've seen nothing to the contrary.
Thank you. And in your representation, you alluded to the noise report that was carried out on Tuesday as happening before licensable activity was permitted. Are you inferring anything from that?
Just a point to clarify. It was just the time of the test was 7:53. Premises into live music till 8 a.m. I just thought I'd make that point. It's indicative. Basically, it's indicative of the situation that we're in. That we identify a problem, and yet what we get back is a knee-jerk response to the point that we're making. But what we'd like is a holistic approach, really, not just a piecemeal thing. So this, okay, yeah, it's a minor point. 7 minutes before they should have music, but why not conduct it during the day when you're allowed to do so? It's just indicative of the management, in my opinion, and I have no confidence in it, to be quite frank.
But music at that time is not breaching any license. It's not licensable activity unless it's carried out as entertainment to an audience. By doing a test, that's not constitute licensable activity. Would you agree with that? I'm happy to accept that point. Thank you. And just one overall thing, you did briefly mention it, but would you agree that things have improved? That Tony is trying to get it right? Things have improved, Mr. Fender, yes. I'll accept that. I actually stated that in my representation, but yeah. Yes, you did. However, I'm not satisfied that things have improved enough. No, I just didn't want to lose the point. That was all. Thank you, Chair. I've got no further questions. Thank you.
Thank you. Mr. Michelli, do you want to add anything? Okay, thank you. In that case, to the other persons, Mr. Evans-Pugh, would you like to make any clarification or points that the Environmental Protection Officer made?
I don't think so. No, thank you.
Okay, thank you. I'll get my camera so I can see the hands going up potentially. Any members like to make any clarification or points from the EHO?
No, thank you.
Anybody else? Okay, thank you all for that. Thank you, Mr. Stone. If you just bear with me. If I could just, the licensing officer, would it be a good time before we go into breakout for video to offer a comfort break to anybody? Would you like that?
That would be a good idea, yes.
Yeah, I think it would be good if everybody's okay with that. We're going to go very shortly and I'll have a declaration to read out. But I think if we could just maybe have a 5-minute break. In fact, let's have an 8-minute break to 11:20. Is that okay with everybody? And we'll reconvene and then go into the breakout for some evidence. Is that okay? Thanks very much. Okay, thank you. It's now 11:20. I think one or two people might not be back. If people can turn their cameras back on that are back, though, please. Welcome back, everybody. I don't intend to take a roll call. I don't want to delay proceedings any further, but unless anybody's got any issues, I'll just go straight to the declaration in a second. I'll just make sure that I can see most people. Okay, thank you for that break. I think it was a good idea. And I'm now going to make a declaration regarding the next part of this hearing. Pursuant to Regulation 14(2) of the Licensing Act 2003, (Hearings Regulations 2005), the subcommittee resolved to exclude members of the public for the purpose of viewing the video footage. If we could now move into the breakout room, please. And if that can just be confirmed, it's done by whoever's done that, so I can continue.
You're getting. Susan, are you all right to put us back into the breakout room?
Is that everyone, Chanel? Everyone? Okay.
Sorry, we had a question just after I said you that.
Okay.
Sorry, Tim, you're muted.
Beg your pardon. If I can just remind people when we go back in that confidentiality still applies. We can all rejoin, please.
Looks like we're all back now, Susan.
Apologies, it automatically went, I think. Are we happy to carry on? Yeah. Thank you, everybody. Okay, we've come out of the breakout room, and this part of the hearing is now for the other persons to present their submission opposing the application. So, Mr. Evans-Pugh, would you like to do that, please? You may be on mute.
I'm now off mute. Thank you, Chair.
Thank you.
So I'm speaking on behalf of two parties who are both residents of Bucklersbury and immediate neighbours of the applicant's premises. And these parties have lived in the properties for, in one case, over 25 years, and in the other case for over 11 years. And I'd just like to say, please don't assume, because they're not speaking to you directly, that they're not interested in this hearing. They remain thoroughly involved and will be following your deliberations closely. The reason you're hearing from me and not from them, and I think you should find this concerning, is that these neighbours have suffered from the activities of this venue over the past year to the point that they don't feel safe appearing in person, showing their faces today. You've just now seen and heard the video evidence from a recent series of late life extensions, which show you what these neighbours are up against. Customers gesturing and mooning at a neighbour's security camera, people in a drunken state running around in circles in the street, shouting and singing and so on. Rowdy customers singing and shouting as they leave. And this behaviour is ongoing, and the neighbours I speak for find it disruptive, and they report to me that they find it intimidating. These parties are not NIMBYs. Rather, they're noise-tolerant urban people who enjoy the buzz of living in the area of town and have never had reason to complain about noise or town centre activities before this current complaint. As proof of this, the property of one of the parties shares a party wall with a pub restaurant, the Red Hart, and the other lives directly opposite a large and busy tapas bar, Los Reyes, which form a pub. Neither party has had any reason to complain about the Red Hart or Los Reyes, either their management or their customers. And they're not doing so now. As you will have read in the written statements, after last year's hearing asking for extended hours, which were refused, as you know, the neighbours were subjected to a vicious social media campaign where they were blamed for the problems the venue was having with its license. We have the applicant's noise management plan, which says the venue is, I quote, committed to develop and maintain good relations with local residents, neighbours, and the local authorities, and that it has an objective to, quote further, minimize disturbance to local residents. This is blatantly untrue, and the neighbours I speak for find it very hard to believe. Residents are not only disregarded as far as noise goes, they are taunted, abused, as you've seen on Facebook and in person, as you've seen from the video evidence. One set of neighbours was so intimidated that they stopped reporting the noise for fear of aggravating more abuse, dealing with customers jeering and pointing at their windows. One neighbour was forced to leave the property temporarily over the summer for a few weeks because the noise and disorder was so intolerable. And now, with this proposed variation, we're led to believe that in a matter of weeks, there's been a road to Damascus conversion. We've yet to see any convincing evidence of a coherent management plan, so we don't believe that the behaviour will change. Ultimately, fundamental issue is that this tiny grade 2 listed building is not fit for such an activity, as has already been detailed, much detail by the Environment Officer, Alan Stone. The last ditch cobbled together ideas around acoustic sound blankets put in place around 3 days ago do not change this very basic problem of sound transmission. Mr. Fender is doing his best for his client by trying to persuade us that hanging sound blankets outside the building will make this venue suitable for the type of entertainment proposed at the hours that is proposed. To prove that, we're given details of a spurious noise test that does not adequately represent the sound generated by the customers shouting into multiple microphones. As Mr. Stone has already explained to you, this is not a representative test. On a purely practical matter, the listed building consent, I think we've covered that. I won't repeat that. We propose that these tests were inadequate and that a full assessment of the premises in relation to the noise and fire safety. There are multiple issues that are of great concern to the neighbours. That's all we have today. Thank you.
Thank you, Mr. Evans-Pugh. I'll be going around everybody to give everybody opportunity shortly. I've just got a query for you, Mr. Evans-Pugh, to start with. I'm not sure if you can answer it or not. The video evidence that we've seen, do you know how accurate I take it the date will be accurate, but do you know how accurate the time is on that?
I believe it is quite accurate, can be taken as correct.
Okay, thank you. And you said that you're speaking on behalf of a number of neighbours. How many people are you actually speaking on behalf of?
3 people living at 2 properties in Bucklersbury.
Thank you very much. As I say, I'm going to come to you shortly, applicant. I'd just like to, in fact, sorry, I'll just put that on ice. I've had a query separately, but I'll put that at the end. Okay, I'll go around everybody, but firstly, Mr. Fender and/or Mr. Michelli, have you got any points you'd like to raise with Mr. Evans-Pugh?
Yes, please, Chair. I was actually going to ask a question about the time and date stamps on the CCTV myself. Mr. Evans-Pugh, in your representation, you made that you alluded to the fact that the CCTV footage showed evidence of the extended hours. Could you just clarify that for me, please? Because that's not borne out on the time of the CCTV footage that we've just watched.
Thank you for raising that. Point out that the sound recordings were taken during the extended license periods. The video footage, as you correctly state, were not.
But there was no actual time on the sound recordings, or not that I could see. Have you got any information as to the times that those were recorded?
In the written submission, the times were recorded. I can tell you the first one was at 01:18 hours, and the second sound recording was at 23:20 hours. The third recording was at 0:04 hours, so 4 minutes after midnight, and the fourth sound recording at 40 minutes after midnight.
But that doesn't obviously appear on the footage that you've provided, but it does appear on the visual footage.
As I said, the sound recordings do relate to the extended hours license. The video recordings, as the timestamp indicate, do not.
And the purpose of the CCTV footage for the incidents, for example, at 7:45 in the evening, 8:20 in the evening, that shows customers in the street. Christine's, is she saying that what we witnessed there is enough to cause her a significant nuisance problems?
Are you suggesting that that one incident is all that has been suffered?
No, I'm just sorry. I'm not trying to trivialize anything. And
it's representative
sorry,
of an ongoing campaign.
I just wondered whether there's any specific messages that were trying to be portrayed through the use of that CCTV footage, or as you've just qualified, you're saying it's representative. So have you, or has Christine cherry-picked what she considers to be the worst bits for submission, or is what you've recorded it?
Just wait. Bear with me a moment, please. Okay. It is representative of disorder in the street, and we feel it's backed up by things that Mr. Stone has submitted as well.
So, and just one final point to clarify disorder. You've just mentioned it's disorder. I saw people standing and talking and shouting in the street. Is that deemed disorder in your view?
If you're asking for a legal definition, I'm not qualified to say. I was referring to the mooning, the gentleman dropping his trousers. And you say you weren't attempting to trivialize this. As well as the video evidence, I believe we all saw a slide showing comments from Facebook. Did you see that?
Yes, I did see that. Of course I saw that, but those comments are made by persons other than the applicant. And I can't comment on those. Like I said, I'm not trivializing anything. I'm just trying to sort of clarify exactly what the point is that's trying to be made here through the use of the CCTV, that's all.
Well, the point is that it is representative, and I think the videos speak for themselves.
Thank you, Chair. I have nothing further to ask Mr. Evans-Pugh. Thank you.
Thank you, Mr. Fenner. Thank you. Mr. Michelli, would you like to make any comment? You're on mute at the moment.
No.
Okay, thank you. Does the Environmental Protection Officer have any points of clarification for Mr. Evans-Pugh?
No, thank you, Chair.
Thank you. Do any members have any points or clarification for Mr. Evans-Pugh?
Can I just say one thing?
You, Mr. Michelli. Yeah, we'll just go back to you then, that's fine, and then we'll go to the members. Go ahead.
One of the videos, when there was lots of people in the streets, they weren't my customers, and we were talking at 8 o'clock in the evening. That's one. Two, the table in question has now been removed after discussions. And as Alan knows, the one night I put a disco light outside, that was removed as well. But the videos are actually interesting. Thank you.
Okay, thank you for those points. Members, do you have any clarification or points you want to raise with Mr. Evans-Pugh? Feel free to shout out rather than put the hand up.
If I may, I just like to come on a point that was actually raised by Mr. Fender, only to say the Mr. or Mrs. Evans-Pugh had provided video evidence to suggest that it is cherry-picked seems slightly odd to me, on the basis that of course you would only provide evidence of the disorder. You're not going to provide evidence, you're not going to provide videos of, you know, a nice quiet street because obviously it's the disorder that's the issue, potentially. So I just want to make that point that it would be odd to provide videos of everything perfectly going normal. In fact, potentially that might be evidence that you would want to provide Mr. Michelli and Mr. Fender if you were trying to dispute the allegations.
Okay. Councillor Stewart Willoughby, I think you're. No, yes, go ahead.
Yes, thank you. We spoke earlier, I believe, about smokers being encouraged to move away from the front of the premises. Was that new directive something that came in after the dates of those videos? Because it's clear that there are people literally congregating out there and smoking.
Yeah, I think it's a fair question, but we're just clarifying with Mr. Evans-Pugh. But if you're happy to answer that at this stage, Mr. Fender or Mr. Michelli?
I beg your pardon.
It's okay. It's okay.
Yeah.
If Mr. Fender's okay with it.
Yes, absolutely. Because I think what the CCTV footage shows was actually some of those customers that were drinking and carrying bags. They were actually using the premises next door to the applicant premises, and that was nothing to do with Mr. Michelli's premises. Just to clarify the point, and this was earlier raised by the other councillor Willoughby, the smokers. Mr. Michelli has a business about 3 doors along from Bucklersbury, a barber shop. And his intention is for smokers to move and smoke outside his barber's shop, where he still has an element of control over them, in respect of knowing where they're going, knowing that they're smoking at the designated area, and then to allow them back into the premises.
Thank you.
Okay, thank you. Does that answer that, Mr. Councillor Willoughby?
Yes, thank you very much.
Great. Just finally then, to give everybody the opportunity, specifically with Mr. Evans-Pugh's submission, anybody got any comments they'd like to make from the members, please? Mr. Michelli, would you like to go again?
Yeah, the bottles you saw outside, a couple of the lads had some bottles. They were not my bottles.
Okay, thank you for that. Before we, I'm going to get to the closing statements point, but I've been asked to just raise or just ask a couple of questions. If you just bear with me, this will be towards you, Mr. Fender and Mr. Michelli. Just some clarification, please. Could either of you just clarify the date that the acoustic pads were installed, please, firstly, as near as possible?
Tony, could you answer that, please?
Okay. I bought the first pads about 6 weeks ago. That was the blue ones, or the blue one, which had sound barrier on it. The latest ones were manufactured on Thursday last week in Leicester. There's 4 of them, 5 layers deep, and they went up on Friday.
Okay, so correct me if I'm wrong. So that the point's taken. Thank you. That the first one's round about mid-August or something like that, 6 weeks ago.
The first one, yeah, probably about mid-August.
Okay, and then these latest ones
wasn't
that we've
sufficient,
seen,
in my view. So I went out and spent £1,200 on 4 separate ones that hang up.
these are the ones that we've seen, the images we've got. Yeah. Okay, thank you. Could you or Mr. Fender also confirm when the internal soundproofing took place, please?
Internal?
Yes, the internal soundproofing.
Right, the internal ones took place, I'm guessing, February, March, April, May time. There was 2
this year. This year, yeah?
Yeah, but that was for the back room. It wasn't sufficient in other people's view, so we moved the karaoke room from the back, as Frank Fender stated, to the front. I'm led to believe the back's now okay.
Okay, that's the clarification I wanted to make. Thank you for that. Okay, I'm going to go into the closing statements, and I'm going to go around everybody to give them the opportunity. Does the licensing officer have any final submissions they wish to make to the subcommittee?
Thank you, Chair. No, I don't have any further submissions to make. Thank you.
Thank you. Does the Environmental Protection Officer have any final submissions they wish to make to the subcommittee?
Is this a summing up statement, Chair? Sorry.
Closing statements, yes, please. Any final
Yeah.
submission?
Sure. Yeah, I'd like to sum up, please, if that's okay.
Yes,
Yeah,
it is. Yeah.
Since the service of the notice in early 2024, February, improvements have been made. The insulation to the wall at the rear you just mentioned and talked about, that seems to have had a positive impact. And other matters. However, even by the noise report submitted in support of this application identify that it's going to be a significant amount of noise escaping through the front of the premises, upwards of 15 dB above background, with the door closed. Obviously, people who need to go in and out, we've seen that from the videos, people need to go out for smoking purposes. When the door is opened, you're not afforded that protection. And so you're going to have periods where you're going to have even more noise than that. That's not been assessed in this report. However, that kind of supports that noise from the front of the premises will be leaving at the front. That's going to impact on negatively, in my opinion, on the neighbouring properties. I was there on the 30th of August. I witnessed significant noise intrusion from that premises. Notwithstanding, these pads are different to the ones that were up then, but I still maintain that any extension to the hours provided at this premises is going to have a negative impact upon the residents that surround this property. We don't know where the noise is coming from. It may be coming from the window upstairs, even when it's closed. We don't know that. We don't know that. No assessment has been made. There's been no mention in this hearing at all about the proprietor controlling the volume and bass controls of the music. To me, that's a fundamental issue that's not even been raised. The system that is in place at the premises is located at the front. There is a volume control. There are a number of microphones that can be controlled. You can reduce the number of microphones. Currently, they have 10 microphones, and quite commonly 4 to 6 are used. That was what I was told at a meeting. That would also further mitigate this problem. In my opinion, the noise has not been adequately assessed to enable a decision to be made to suggest that it's going to be okay to open till 1 AM in the morning. That's my assertion. I'm still not convinced that the neighbours will be negatively impacted by any extension to the licence. Up to 11 o'clock, you could say, is an average person's sleep time, going to bedtime, an adult. 1 o'clock, you could argue that most people are sleeping on a Friday and Saturday night. Maybe if you're party animal, you wouldn't. But the average person would be intending to sleep or asleep at that time. I'm not comfortable and recommend that I object to this application, and I encourage you to do so. That's all. Thank you.
Thank you, Mr. Stone. Mr. Evans-Pugh, do you have a final closing statement or any final submission you would like to make?
I'd just repeat that the neighbours I speak for object to this application and urge you to reject it.
Thank you. Mr. Fender and Mr. Michelli, I'm going to come to you in a second, but could I just, Mr. Michelli, could I just ask you something? It might save you when you make your closing statement, if you're going to. Do you review your own CCTV, or have you, to compare that to the footage that's been provided by Mr. Evans-Pugh? Mr. Fender or Mr. Michelli could answer that, please.
Frank, I'll answer. I have looked at my CCTV, and obviously it doesn't cover the street like my neighbours does. So I can only see in front of the door. So the two videos we saw of the two young ladies at 10:30 outside, I couldn't see. And the other video, which isn't acceptable, obviously, the gentleman doing a moonie, you can clearly see me telling him to quieten down. He had two bottles that had nothing to do with me. I've then gone back inside and he done a moonie. that I couldn't see from my CCTV. But you can clearly see me telling them to keep quiet. And that's it. Is that
Okay.
good enough answer?
I think
Thank you.
And the other
That's
thing I'd
clarified.
mention is the 10 mics, that's now down to 2, Alan. I've told you that a million times. We've got 2 mics in there now.
Okay.
No
Well, if I'm
longer-
just, if it's fine, I'm more than happy for. Let me just come to you to give you an overall closing
No,
statement,
no,
if
Frank
you'd
could
like
do
to. But
that.
yes, by all means, make that point if you wish to. So, does the applicant, in closing statement form, wish to make any final submissions? Could I come to you first, Mr. Fender?
Yeah, yes, please, Chair. I just want to add on from what Tony said about you asked about comparing CCTV like with like.
Yes,
that wasn't actually possible. With the CCTV was viewed by Tony. Tony had to go to the council offices in order to view that with Sharon and Jasmine. He was not allowed to take any photos or take anything away from that. So, and the footage, for obvious reasons, couldn't be forwarded to us in advance anyway. So to be able to sort of compare like with like would not have been possible in these circumstances. So I think that answers your question there. I'm grateful for Mr. Stone to show that since the last hearing, things have improved. Things have improved. You've heard that. Soundproofing has taken place. Tony is doing his best and his utmost and still trying to think of things which he can do to sort of reduce the potential for noise nuisance, to reduce the potential to improve the way that his customers can be controlled. The CCTV footage that we've seen in closed session, I'm not convinced that actually takes us anywhere. In fairness, it shows a town centre. It shows quite a deserted town centre, in my opinion. But I certainly didn't see any evidence of disorder. There might have been raised voices. But what was also interesting to note on the CCTV footage, we couldn't actually hear any music either, which, considering that the objections seem to be because of the music that's from the outside going inside to other premises, was quite a surprise to me. I was expecting to hear karaoke in full swing, but I certainly didn't hear that. What I did see was groups of people standing in the street. In respect of their behaviour when they're in the street, yeah, we've heard that some of them weren't even Tony's customers. We can understand that. But people have a responsibility for their own behaviour. That's even included in the Section 182 guidance. You can't use licensing as a means to control other people's behaviour. And Tony can only be conditioned with things which are under his direct control and for which he can have influence. The licensing subcommittee has to have confidence, of course, that the applicant will be compliant with what is proposed. You may have doubts about this due to past demeanours. However, over the past few months, he has sought professional advice regarding his legal and social responsibilities. He is far more knowledgeable. He is much more aware. He is very aware of the consequences of it not being compliant. That would include, of course, being compliant with both licensing and planning regimes. He fully understands that one does not negate the other. And I think that's very important, given the advice that you've been given by your legal advisor in respect of planning, Grade 2 listed building, etc. So you've also just heard Tony mention that he's willing to reduce the number of microphones in use at the premises. That was part of the discussion that we had when we had a meeting with licensing himself and ourselves. That could be conditioned, that could be introduced into the noise management plan. Tony is quite committed to using no more than 2 mics. He understands the risk when other people are shouting into microphones. He's doing a lot. He wants the ability to be able to trade until 1 o'clock in the morning on a Friday and a Saturday night, not just for his business, but also because it meets customer demand as well. In the opening statements, we heard that in one of the council plans is to promote a diverse range of entertainment, etc. Karaoke is one of these diverse breeds. It's a bit of a Marmite thing. You either like karaoke or you don't. Clearly, Tony's customers do like it, and he wants to be able to provide it for longer on a Friday and a Saturday night. But he also understands that he's got to do that in a way that does not affect neighbouring properties. I would therefore ask you to grant the application, please. Add in the conditions proposed and agreed with the police, and and also adding conditions as proposed through the application and what you've heard here this morning. Thank you, Chair.
Thank you, Mr. Fender. Mr. Michelli, have you got any final submissions you'd like to make?
No, thank you.
Okay, thank you. Just bear with me. Can I now please invite the legal advisor to summarise any legal issues that have been raised at this hearing?
I'm grateful, Chair. It would appear from the application and the representations that the committee have heard today that principally there are two licensing objectives which are at the heart of this application. That would be the prevention of crime and disorder and the prevention of public nuisance. The applicant submits that in effect and has put forward measures that he has taken and proposes to take that would meet, that would prevent the licensing objectives being breached and therefore would go that some way to allaying any fears and concerns that have been raised and would support the application being granted. This committee will need to consider that evidence and consider whether or not they meet any concerns in relation to objectives and in particular whether or not it's appropriate to grant the application. Specifically on the issue of crime and disorder, the applicant has put forward a number of measures, including the provision of doormen, and certainly the evidence for Mr. Stone is that the measures which Mr. Michelli has taken have improved the situation from the situation obviously previously, but this panel and this committee will need to consider whether that improvement has gone far enough and is sufficient to allay those concerns. And of course, you would need to decide what weight to give to the evidence of Mr. Stone that although there has been an improvement, the concerns remain even with these measures that have been put into place, specifically around doormen and in terms of employees being on the premises. Now, in addition to obviously that particular objective, the second point is the prevention of public nuisance, which appears to be particularly important. The applicant put forward his primary method, which is the installation of acoustic pads. And of course, this committee will note that at section E3.4 of the local authorities licensing policy, that makes clear that the installation of acoustic barriers are a permitted measure to prevent public nuisance. But however, that policy also goes on to say that where such equipment is installed, that may require planning consent, and applicants are advised to discuss any intended changes prior to them undertaking works. Mr. Michelli has also given evidence about when these barriers went into place, but the committee has no evidence that there was any discussions with planning prior to those changes taking place. Therefore, it will be for the committee to consider what weight to put onto the fact that Mr. Michelli has not had those discussions prior to obviously this application taking place. The committee is of course entitled to receive planning considerations and indirectly those have been raised by Mr. Stone on behalf of environmental health. It is unclear whether the installation of those pads, given the particular heritage considerations of the premises, and whether the measure is capable at all of being used in these premises if, because of heritage considerations, they would not be permitted in any extent. Of course, the committee is unable to say whether that would or would not be the case because it does not have any particular information to that. But the committee is obviously reminded of the local authorities policy that wherever possible, they should try to avoid a conflict between planning and licensing conditions, and these will need to be considered. Planning regime and the licensing regime are of course distinct, as made clear by Mr. Fender, but the committee will note that nuisance and crime and disorder are shared concerns of both regimes and feature across both regimes. It is also the case that even where lawful planning permission exists, or if the committee decides to deem or assume that there is lawful planning for the installations that have taken place, that does not, of course, preclude you from refusing the application if applying the licensing framework there is an appropriate reason to do so. There was some discussion in relation to the issue of crime and disorder and whether or not particular acts and images recorded fell within that. This committee is advised to give crime and disorder their ordinary plain English meaning, and it will be for the committee to assess whether, in their view, there has been demonstrated that crime and disorder or disorder has taken place, but also the committee is reminded that they must be by patrons of less party. If the disorder is by patrons of other premises, then the behaviour of those patrons cannot be used against Mr. Miceli as a reason to reject his application. And so those are the legal points. The committee is invited to consider the local policy as well as the 2003 guidance to make its decision.
Thank you. Thank you very much. Before I hand over to the committee member and scrutiny officer for the next part of the process, I'd just like to thank everybody who's spoken for the measured and objective way all the arguments have been put. So thank you for that. Committee member and scrutiny officer, could you explain the next part of the process, please?
No problem. Thank you for that. The subcommittee will now be retiring to make a decision in private. Public viewing the meeting are welcome to wait to listen to the decision. However, this may take some time. Once the subcommittee has made its decision, this will be announced via the live stream. If members believe that the decision will take too long, to avoid parties waiting, they may decide not to announce the decision live today. If this is the case, an announcement will be made to the effect by the subcommittee and the meeting will be closed. The decision would then be announced in writing within 5 working days of the meeting. Members and legal officers will shortly be leaving an invitation to a breakout room. Receiving an invitation to the breakout room. The applicants may stay or leave if they would. A holding notice will be displayed in the Zoom call and the live stream will continue. And please note that as the live stream is ongoing, anything said during this time will be recorded, so please ensure you mic your phone. Your microphone is muted. Thank you very much. And we'll be moving to the private room shortly.
Thank you.
Susan, are you all right to take the holding slide down? Lovely, thank you. I think Mr. Fender's just walked away, so I'll just wait for him to come back. Hello and welcome back. I'm just going to do a quick roll call to see who we have here at the moment. Do I have Councillor Stephen Patmore?
Yes, present.
Councillor Tim Johnson? Can you hear me, Councillor Tim Johnson?
I beg your pardon. Yes, I'm here. Thank you.
Councillor Stuart Willoughby?
Yes, I'm here.
Councillor Alistair Willoughby?
Yeah, here.
I have Sharon Bartram.
Yes, I'm here.
And do I have Jasmine Jennings at all? Might not be with us yet. And Samal?
Present.
Lena?
Present.
And do I have Alan Stone?
Yes, hi, Chanel.
Is Scott Grant with us?
Good afternoon. Yes, I'm here.
And do I have Tony Maselli? Thank you. And Frank Fender?
Yes, present. Thank you.
Okay, I will move over to the chair for his announcement.
Thank you, Chanel. Just bear with me while I get the details up. So I'm about to announce the determination of the hearing. I'd just like to thank everyone again for their attendance today. I will read the determination in full, but it will be published obviously in due course and open for people to get copies of it. There won't be any questions on it or any comments asked for. And at the end of the decision notice, I'll close the meeting. So the decision notice is today's hearing, the 3rd of October 2024, to decide whether the licence holder Antonio Micheli of Let's Party at 26 Bucklesbury can have an extension to his licence under the agreed days that we've all discussed at length. It's an application for a variation of an existing premises licence under Section 34 of the Licensing Act 2003. The subcommittee has read the material presented to it and has listened to all the evidence and submissions. The subcommittee has considered the national guidance and the statement of licensing policy and has come to the following decision. The subcommittee has decided to refuse the application. The subcommittee has found that the licensing objectives have not been met by the application and is not satisfied that any amendments to the application or conditions attached to the licence could ensure that the licensing objectives are met. The licensable activities, timings and conditions on the existing premises licence remain unchanged. The subcommittee recognises that conditions would only be imposed on a licence where conditions are appropriate for the promotion of one of the 4 licensing objectives which are on the decision. The subcommittee did not feel the need to impose any conditions. The effect of failure to comply with any of those, but it isn't relevant because we haven't imposed any there, but if they did, would lead to fine or criminal conviction. The subcommittee has taken into account the guidance issued under Section 182 of the Licensing Act 2003. And again, the sections of that Licensing Act will be published in due course. And the subcommittee has also taken into account the North Hertfordshire District Council's statement of licensing policy, and the numerous sections therein will also be published. The rationale for this decision. The committee notes that the premises are a Grade 2 listed building. The committee was concerned that whilst the installation of the acoustic barriers was made with good intentions as a permitted measure to prevent public nuisance, it was concerning that the applicant had not considered that the installation might attract planning control and was unable to produce any objective evidence that the installation was lawful. Given that this installation is a central part of his noise management plan, the committee considered that there was no good reason given for why the applicant had not consulted planning as advised in the local licensing policy. As a result of the applicant's omission, the committee was deprived of the opportunity to consider the viewpoint of the planning department as envisaged in the local licensing policy, and determined that there would be a real risk of a clear conflict between the decisions of the two regimes, which is not in the interests of the applicant or the community. A breach of planning control goes to both crime, as it is a criminal offence, and also to public nuisance, as it is unclear the condition of an acoustic barrier is capable of being met by the applicant without him breaking the law. Without one, the committee was satisfied that there would be a public nuisance. Further, or alternatively, even with the current acoustic barrier, the committee was only able to give limited weight to the evidence of the applicant about how effective it has been or would be to prevent public nuisance. This is because the recording was taken at a time that did not replicate the conditions that would be experienced by the community at the times that the premises are used as a karaoke venue. It is relevant to consider the noise from the music being played alongside the noise created by the visitors of Let's Party in order for there to be confidence that the noise levels would be at acceptable levels. The committee gave limited weight to the evidence of Mr. Stone about his subjective perception of the level of noise and considered that a recording of some form would have been helpful, even if a decibel reading was not taken. However, when considered alongside the recorded evidence provided by the objectors, it was clear that the level of noise being experienced by neighbours was not at acceptable levels. However, the committee also wishes to make it clear that the recordings provided by the objectors predated the date when the applicant put in some of the more recent measures, and therefore, had there been better and more reliable evidence of the potential effect of the acoustic barrier, the absence of recent recordings of noise nuisance, notwithstanding the concerns of reprisals, may have resulted in a different decision being made. The committee considered on the overall evidence that there has been a number of concerns over a prolonged period over the management of the premises, and that to vary the premises licence to extend the hours of operation would not be in accordance with the licensing objective until there is demonstrable and prolonged evidence of the licensing objectives being met on the current licensing terms, and the committee noted that the applicant, adopting many of the conditions that he had proposed or formed part of the noise management plan, would go a significant way towards the future prospects of any future variation application. However, given the problems experienced with antisocial behaviour and disorder, extending the drinking hours to 1 AM would be likely to see an increase in antisocial and criminal behaviour and disorder without a robust management plan being in place with the evidence to support its effectiveness. The committee found that the applicant was being reactive instead of proactive based on the evidence before them. This decision takes immediate effect. There is a right of appeal that's being published in the decision, and rights of review following the grant of a premises licence is also published in this decision. Just leaves me to thank once again everybody for taking part in such an objective way, and I'm now going to close the meeting.